Let me give you a couple of examples of what I'm talking about. This is a nominee to the federal district court in Colorado, a Biden nominee. His name is Cato Cruz. And John Kennedy did it, Senator John Kennedy from Louisiana, did it to another Biden nominee who was unprepared for a committee hearing on his candidacy, his nomination. Cato Cruz queried by Senator John Kennedy about his knowledge of the law, federal district court judge. Mm-hmm. And I won't reveal it at the outset, but the question that Senator Kennedy asks is something that a federal district court judge should know. This is not an esoteric reference that Kennedy makes in the question.
Tell me how you analyze a Brady motion.
How I analyze a Brady motion?
Yes.
Senator, in my 4.5 years on the bench, don't believe I've had the occasion to address a Brady motion in my career.
Do you know what a Brady motion is?
Senator, in my time on the bench, I've not had occasion to address that, and so it's not coming to mind at the moment what a Brady motion is.
Do you recall the U.S. Supreme Court case, Brady v. Maryland?
I do recall the name of the case, Senator, yes.
And what did it hold?
I believe that the Brady case, Senator, I believe the Brady case involves something regarding the Second Amendment. It is not. I've not had occasion to address that. If that issue were to come before me, I would certainly analyze that Supreme Court precedent and apply it as I would need to the facts in front of me.
Thank you, Mr. Chairman.
Not only does Brady v. Maryland have nothing to do with the Second Amendment, it's clear that he was, as he's searching for an answer, he thinks Brady. I wonder if that has something to do with Sarah Brady and Jim Brady and gun control.
Right.
Brady v. Maryland was decided 60 years ago.
Ooh.
And by the way, it's something that anybody who goes through law school and takes a criminal law course like I did would be exposed to. And it's kind of important because it set the precedent that the prosecution is required to turn over exculpatory evidence to the defense. That's kind of a big thing in criminal law, not an esoteric thing. And so when you have judges like that on benches at the state court, federal court, not to mention lawyers in public defenders' offices who about have the same handle on the law and vigorous representation of their clients as Judge Cruz does. Yeah, I get a little jumpy when the state is in the position of deciding who lives and who dies. And by the way, just as a refresher, I say John Kennedy did it again because just a few weeks ago, we played it for you here, John Kennedy, senator from Louisiana, asked questions of another Joe Biden federal district court nominee, Charnel Jekelgren. These are also not esoteric questions, as should be readily recognizable to you.
Thank you, Mr. Chairman, and congratulations to all of you. Judge on the far end, tell me what Article 5 of the Constitution does.
Article 5 is not coming to mind at the moment.
Okay. How about Article 2?
Of the Constitution?
Neither is Article 2.
Okay. Do you know what purposivism is?
If you didn't know what Article 5 and Article 2 was, good luck.
In my 12 years as an assistant attorney general and my 9 years serving as a judge, I was not faced with that precise question. We are the highest trial court in Washington state, so I'm frequently faced with issues that I'm not familiar with.
Look what I
and
have
I thoroughly review the law, research, and apply the law to the facts presented to me.
Wonderful. And one of these days I'm going to get around to reading the United States Constitution. I'm only a trial court judge in the highest court in Washington state. Article 2 is the executive branch. Article 5 is amending the Constitution. Purposivism, I mean, it doesn't sound as high-minded as it is, it's not as high-minded as it sounds with the word purposivism. It just means interpreting legislation based on the legislative intent, the purpose of the legislation, thus purposivism. But these experienced judges, hey, but I don't know anything, but when something is presented to me, I thoroughly investigate. I mean, base of knowledge is a requirement, it should be, for positions like this, sitting in judgment of people.
This is bad.
And so now think about imposing the ultimate punishment and tell me that you're completely comfortable with what you see, and particularly in our hyper-politicized times, in prosecutors' offices, in public defenders' offices, on the bench. Not me. For more on this, because there's a case out of Texas that speaks to my point, I think. We're pleased to be joined by Dr. Sally Satel, who's a psychiatrist and senior fellow at the American Enterprise Institute. Dr. Satel, thanks for joining us. Appreciate it.
Thank you.
So tell us about this case out of Texas, and I got some real questions about how it got to this point, but the case of Andre Lee Thomas, who is a death row inmate in Texas and scheduled to be executed.
Yeah, this is a terrible story, and I suppose I should warn that some details of this crime are pretty gruesome.
We can
I
take
won't
it.
go into. Okay. So this Andre Lee Thomas, now he's 39, but he's been on death row since 2004 for a crime, as I said, quite awful. But he was someone with paranoid schizophrenia, which means he was subject to delusions. And in his case, he believed sincerely that his ex-wife was Jezebel, that two of his children were possessed by the devil. And so he attacked them, actually cut out their hearts, and put them in his pocket, and then stabbed himself in the chest, intending to die. But he didn't. He survived, and he went to the police. And he admitted what he did and asked whether he'd be forgiven. He told the police that he thought this was the will of God, and kept wondering if his family was really dead. So obviously this is the product of a deranged mind, not a callous, hardcore, standard criminal. And when he was in jail, he was reading the Bible and came across this famous verse, Matthew 5:29, which says, if your right eye causes you to sin, gouge it out and throw it away, and that's what he did. So he blinded himself. He went on trial about a year later. He was considered to be competent to stand trial because he was very psychotic at the time, and a person cannot go to trial until they've become competent, meaning that they understand the charges against them and can cooperate with the counsel. So it took about a year, and obviously needed significant medical attention for blinding himself. And with psychiatric medication, he could participate. His lawyers asked for not guilty by reason of insanity, which sounds like a very reasonable defense. But because he had possibly taken several pills of cold medicine before the crime, it was the prosecutor successfully argued that really his murders were the product of drug effects and not a primarily psychotic mind. And so he went on death row. And this is one more awful detail. He was psychotic on death row, still on medication, but not responding well. And at one point, several years later, I think 2008, he thought that the government was reading his thoughts and doing that through his remaining eyeball. So that was removed by him. So now we have a blind man who's psychotic and was scheduled to be executed on April 5th. His lawyers, about 2 weeks ago, were able to convince the Board of Pardons and the governor to stay the execution. They had originally asked just for it to be commuted, so he would spend the rest of his life in prison. But at the very least, they said, can we have more time to demonstrate that he is not competent to be executed. That there was a Supreme Court ruling in 2007 which said that it is a violation of the Eighth Amendment, that's cruel and unusual punishment, to execute someone who doesn't know he's being executed, or maybe does know he's being executed, but has a fanciful understanding of why that's happened. And in fact, the case is called Panetti and Quarterman, and the defendant thought that he knew he was being executed, Mr. Panetti, but he thought it was because the state didn't want him to preach the gospel, not because he had killed people. So that's where we are now. His lawyers are collecting data, getting psychiatric exams to try to make the case that Mr. Thomas is not competent, that he doesn't really understand why he is scheduled to be executed. And if they succeed, they will either push his execution date further back, or they will just commute his sentence. I can't imagine how they could think he could ever become competent. So, yeah.
How did this case not get pled out? I mean, how did it get to the point where it actually went to trial and he was convicted, and then the death sentence was imposed? He obviously did it. He admitted he did it.
He put their heart in his pocket.
How does defense counsel not go and say, okay, take the death penalty off the table, and then let's argue about either life in prison or life at a psychiatric institution until he's deemed fit to be released?
Well, now it sounds like you are a lawyer, right? Well, I'm not, so I don't know the details in great depth, except to say that, I mean, their attempt at doing that was to have a not guilty, by reason of insanity defense, and this case is complicated further by having there was questions about whether the jury was racist. Andrew Lee Thomas is black. The woman he killed, his ex-wife, was white, and during the jury, the voir dire, there were people who were selected, but who had very critical things to say about intermarriage. And in fact, this as a Sixth Amendment issue. In other words, quality, of fair counsel, was just brought to the Supreme Court a few months ago to try to basically vacate the situation, because his trial was basically unconstitutional because of these jurors. And the Supreme Court did not honor that, although the three liberal justices actually published a dissent, which I gather is a bit unusual. Often they just say they're not going to deal with it, but they felt strongly about it. Justice Kagan and Mayor, and why am I blocking on the other liberal justice? Oh, the new
KBJ. Yeah, Ketanji Brown Jackson.
Yes.
But as I read from your piece over at National Review, there were different psychiatric evaluations presented at trial. One believed him not to be competent to stand trial, and the other believed that it was a matter of impulse control, but that he understood the difference between right and wrong.
And it gets worse. One of the psychiatrists who examined him, I just find this so unbelievable, thought he was malingering. In other words, thought he was exaggerating his problems by blinding himself, which is just mind-boggling. But yeah, there were questions also whether he was competent to stand trial at all. Whether he was really below the threshold of completely understanding the charges against him and ability to cooperate. So that was a question. But I don't want to sound cynical, but this is a town called Sherman, Texas, which I gather is, just a very traditional, punitive-oriented when it comes to these kinds of cases. And also, again, these are just details that have nothing to do with the larger point. The larger point being, why are we even executing people with severe mental illness? But apparently the main lawyer was kind of sick and not doing a very good job. And
here we go.
So
Yeah, there we go. The competency of counsel, but I mean, so yeah, I mean, you can be punitive because the crimes are so horrific. People say, well, that person needs to be executed. I can understand that visceral reaction, but then you get the full context, and maybe a lot of people haven't.
Of course.
And then you say, well, wait a second, and then you look at Supreme Court precedent on the topic, and there's a couple of cases that seem to me relevant to this discussion, and you say, well, wait a second. And then hopefully Greg Abbott, the governor there, will say, as you said, he stated, will say, wait a second, too, and commute it to life and then hash it out whether he belongs in prison or a facility. But, I mean, this is a good case of sort of what I was talking about at the outset where, just be careful how much absolute trust you put in absolute authority because there are just cases that you can't imagine. And there are performances from quote-unquote professionals that you also can't imagine. And when the can't imagines come together, then something you can't imagine can happen that you'll regret.
Yeah, I'd like to say something that's a little optimistic here.
Okay.
I happen to believe that, I mean, who knows, but I happen to believe they will commute his sentence. There's a lot of people have written letters and bishops, and he's gotten a lot of sympathy. For 2 points. Well, first is that in 2002, the Supreme Court did decide that people with intellectual disability, and at the time the term was mental retardation, should not be held. The Atkins
decision.
Yes, the Atkins decision, right. That if your IQ was below 70, that wasn't in the decision per se, but that's typically how it plays out. If an IQ is below a certain threshold, then a person would not be eligible for the death penalty. Doesn't mean they won't be punished, and they may well get life in prison, but they won't get the death penalty. So that is a bit of a precedent when it comes to the idea that, if you're not rational in the case of severe mental illness, then your moral reasoning is defective. And if your moral reasoning is defective, then you can't be blameworthy in the way most people are, and then your punishment has to be different. And the second thing I just wanted to mention is that a number of states, Ohio leading the pack in 2021, passed a law with strong bipartisan support that exempted people with severe mental illness who were psychotic at the time of the crime. Now, it's very important. Who were psychotic at the time of the crime, like Mr. Thomas, believed just delusional ideas about his family, that they could not be executed. And it's retroactive. So if there are people on death row now who were psychotic at the time of the crime, but didn't meet that very, very high bar for not guilty by reason of insanity, which is a very high bar, and some people don't meet it. Some people have poor representation. In the case of Mr. Thomas, I think it's fair to say. But that's an excellent law. And Kentucky passed one a year later. Unfortunately, it's not retroactive, but it's something. And Texas is even considering one, and a few more states. So, and then if the case comes before the Supreme Court that's relevant, they should, in my opinion, consider this also a violation of the Eighth Amendment, as they did for executing people who are mentally retarded. And that would be a good outcome.
Well, again, I think Governor Abbott's a pretty decent guy, so to the extent that he gets the full picture here, hopefully he does the right thing, as you suggest optimistically. She is Dr. Sally Satel, psychiatrist.